This morning, Chicago is on one side of a Supreme Court showdown over handguns. The justices are asked to decide whether the Constitution's Second Amendment applies to local gun laws. Attorney Thomas Glasgow returns here this morning to help us understand this case that's before the High Court and what will happen today. The hearings will happen at 9 o'clock this morning. Good morning, Thomas.
Good morning.
Always good to have you here.
Good to see you.
So give us a quick breakdown of this case. What is the City of Chicago saying? What's the argument on the other side?
The City of Chicago is saying because the Second Amendment only applies to the federal government under the Bill of Rights, under selective inclusion, that it shouldn't apply to states and it shouldn't apply to municipalities. So therefore, the Heller decision, the decision in 2008, that was the Washington, D.C. case that struck down the Washington, D.C. handgun ban, should not apply to the City of Chicago because the Second Amendment simply doesn't apply to states. It only applies to the federal government. That's their argument.
And Mr. McDonald on the other side says
that this has been ruled a fundamental right under Heller, and because it's a fundamental right, the Supreme Court should include the amendment in its 14th Amendment, which is where all the Bill of Rights have been applied to the states, and therefore it should be struck down.
Now, you mentioned the Heller decision, which was the Washington, D.C. case. So if it already ruled, overturned a ban in Washington, D.C., how is Chicago different?
Chicago is different because Washington, D.C. is a federal enclave. It is ruled by the federal government. There are no state powers there. And the Bill of Rights, the amendments that we know of as the 1st, 2nd, 3rd, 4th, 5th, etc., originally only applied to the federal government. It was only applied to the states through the 14th Amendment after the Civil War, and only selective amendments have been applied to the states. What McDonald is asking is to apply all those amendments to the states and strike down previous rulings that only gave selective inclusion to the amendments.
How did this case end up before the High Court?
It ended up before the Supreme Court because once the Heller decision was decided, Chicago and various other places in the area had handgun bans. The people who are gun proponents said, hey, this is unconstitutional. It's been ruled unconstitutional in Heller. Now's our time to strike. 137 years of erosion of gun rights really are beginning to be reversed, so we should go forward with it. Illinois and Wisconsin are the only two states left in the Union that don't have any kind of a handgun or concealed weapon statute. Almost every other state in the Union has some type of concealed weapon ban.
And what do you think is going to happen today?
What's probably going to happen with the arguments, there's going to be very spirited arguments on both sides. The justices are going to be asking very pointed questions to both the proponents and the opponents of this rule, and they are then going to take into consideration what they are going to do. They will retire, and several months from now we will come out with a decision that is either following Heller and expanding those rights or curtailing them under some form of keeping the ban in place.
So the decision won't come for several months, you said?
Probably not.
Thomas, thank you so much for coming in today.
It's nice to see you. Thank you very much for having me.
Once again, defense attorney and our legal expert here. Right now we're going to check.